Okay, I'm going to talk about two things in this video. The first thing is public concern at work and their news that PIDA is not protecting whistleblowers. And secondly, I'll be reading a statement that I've put up today regarding what happens to whistleblowers. So, to start with PIDA, PIDA are the charity, Public Concern at Work are the charity that, played the key role in drafting the Public Interest Disclosure Act. It was so badly written, it was never designed to go into court. It was written for negotiation and whistleblowing policies, and basically anything but the public interest was served in PIDA. Our case was the first case, the BUPA 7 whistleblowers was the first case to use this law, and it was a total and complete betrayal of people's trust. It was worse than no law at all. We actually left no stone unturned and wrote to every government department, every member of the House of Commons, every member of the House of Lords. We went down every avenue, hundreds and hundreds and hundreds of letters that we have. There is nobody that can say they did not know. The response that we got from Tony Blair's government at the time was no comment when we actually highlighted that PIDA was a flawed and useless law 16 years ago. Since that time, whistleblowers' lives have been ruined. The few that can access PIDA. We've said this for 16 years. And when our case went through and the injustice that happened, we took our case to Public Concern at Work with all the evidence, and all they cared about was that our case reflected badly on their law. They sell policies and procedures to industry, that's where their income comes from, and their law abrogates the use of policies and procedures, so there's a conflict of interest there. And now they're announcing, PIDA is failing whistleblowers. Well, my God, you wrote the law, and you are the ones that are failing whistleblowers. People's lives and their families' lives have been destroyed, utterly and completely destroyed. And you've got the cheek to turn around and say, actually PIDA is failing whistleblowers. Well, all I can say is that we will fight for a public inquiry, which will include looking at Public Concern at Work's actions, when it comes to this law, and the actual government's response at the time, and subsequent governments, to basically suppress the fact that they had, that whistleblowers were not protected at all. And then we were given the shambles of Robert Francis, which I won't even go into because it's not worth my breath. But Public Concern at Work, we are on your case, and you are going to be held to account for how you've betrayed whistleblowers. You're the last people that a whistleblower should go to. You would have noticed in the last few weeks, since the Des Kelly Dear Des video went up on YouTube, which is, I have no words for it, to find David Behan and Andrea Sutcliffe, among others, lauding this man who is responsible for Edna's abuse and the abuse of other vulnerable people. Since then, I've decided that our case and the injustice of the BUPA 7 case, I decided to put it to one side so I could fight for other whistleblowers, not to go through what we went through. But I realise now that that was the wrong thing to do. I should have continued to fight, even though we did thousands of letters, because the only way to help other whistleblowers is to expose what happened to the first PIDA case, and then the domino effect will happen and all PIDA cases will fall. And I'd like to read you something that I've put up today regarding Des Kelly, and some evidence just on one point. There's 300 points that we're going to be publishing, but we've only just started publishing some of the evidence, so you can see what went on. Okay, in light of the recent public statements by David Behan and Andrea Sutcliffe of the CQC with regard to Des Kelly OBE, I will be publishing all the 300 pieces of independent factual evidence that proves what Mr. Kelly knew when he knew it and what he did about it. All those who have harboured Mr. Kelly and allowed him to rise to such a powerful position will have to answer for the stance they have taken in protecting a man who denied and covered up abuse and consistently called the whistleblowers liars. Mr. Kelly recently featured in a Guardian newspaper article by David Brindle. This article said Mr. Kelly brought up the case of the BUPA 7 and said he was anguished by what happened. The suffering inflicted on defenceless elderly people is real anguish. And the article concluded, the truth may never be known. I stopped fighting the injustice in order to help others, but realised the best way to help them is for the truth to be known and for all whistleblowers to be protected by a full inquiry by jury into all historical whistleblowing cases, starting with the first case under the Whistleblowers Law, that is the BUPA 7 case. The truth will be known, and shame on all those who stood with Mr. Kelly, because we stand with Edna. The conclusions of the Ashford Employment Tribunal all depended on the credibility of Mr. Des Kelly. This section deals with just the issue of the redeployment of the abuser, Maria Keenahan, referred to as MK. Mr. Kelly's evidence. Note, after the exchange of evidence took place and Mr. Kelly had seen the applicant's statements, he submitted a further statement changing his evidence. Mr. Kelly's first statement. This contains no reference to the first attempted redeployment of Maria Keenahan at Anne Sutherland Care Home, no reference at all to any home or to any possible redeployment being stopped. Mr. Kelly's second statement, paragraph 53, I quote, on the 14th of December 1999, I was advised of concerns by the RIU, the Registration and Inspection Unit, of the redeployment of Maria Keenahan to Faircroft, another home in the Care First registered with Bromley, but not operated as part of the Bromley contract, unquote. Mr. Kelly makes no reference at all to the earlier attempted redeployment of Maria Keenahan to Anne Sutherland House. The BUPA 7 whistleblowers all included in their witness statements the following evidence. 1. At the end of August 1999, the 7 whistleblowers discovered that Maria Keenahan was to be redeployed to another care home, Anne Sutherland House, after the August bank holiday weekend. They disclosed this to the regulator, Richard Turner, who immediately took action to stop this happening. 2. Early December 1999, the whistleblowers discovered Maria Keenahan was working at Faircroft Care Home. They immediately informed the regulator, who were completely unaware of this. When there are two different versions of events, I would expect any independent expert evidence to be considered. The independent evidence from Richard Turner of the RIU, who were the prescribed regulator under PIDA, the Public Interest Disclosure Act. Richard Turner's evidence, paragraph 46. On the 27th of August, I received information via one of the managers of another residential care home in Care First Partnerships Limited Group, who reported to Monica Hanscom, a regulator inspector, that Maria Keenahan was to be re-employed at Anne Sutherland House, another home in the group, in a similar capacity to that she had had at Izzard House. It was on or around that date that I also received a call from Eileen Chubb to say that Maria Keenahan was to be re-employed at Anne Sutherland House as a team leader on their unit for the elderly mentally infirm. At that time, Maria Keenahan was under arrest and on police bail whilst we were making further inquiries regarding theft from residents, unquote. Paragraph 47 of Richard Turner's statement, quote, we managed to ascertain that Maria Keenahan was due to start work first thing on Tuesday the 31st of August after the bank holiday Monday. On the evening of Friday the 27th and over Saturday the 28th and Sunday the 29th, I contacted Mr. Kelly at his home and said that the re-employment of Maria Keenahan at Anne Sutherland House was unacceptable to us, especially as she was on bail with regard to allegations of theft, and secondly, that in our view she was implicated in both abuse and neglectful behaviour, either by herself and members of her team, and that she was managing on Unit 3, Izzard House. He ultimately agreed to prevent her from commencing employment at Sutherland House on the morning of 31st of August, which I understood that he did because I phoned Anne Sutherland House to confirm that this had happened. Richard Turner's statement, paragraph 48. On the 1st of December 1999, Eileen Chubb and Karen Hook came to the Civic Centre and spoke with Monica Hanscom and Carl Sewell, the Chief Executives and Monitoring Officer, and informed them that Maria Keenahan had been at Faircroft, a care home in the management of Care First Care Homes Limited, and not under direct contract to the London Borough of Bromley, BUPA, by the way. They don't like us using that word. Paragraph 51. We looked at the records at Faircroft from which it appeared that the rotas had been altered and the name Maria tipexed out on at least one of those I had seen. This rota was hanging in the office upstairs. Further rotas were held in the manager's office in the basement, which we did not have access to that evening. We returned at 8:30 the following morning and waited for the manager to arrive at 9:15. We interviewed Mrs. Edmonds at that time, and she finally agreed that Maria Keenahan had worked at Faircroft since September. Paragraph 53, Richard Turner's statement. Carol Newton, BUPA Regional Manager, had brought Maria Keenahan to Faircroft at a time when the manager was not on duty. We subsequently ascertained that this had occurred on August 31st, immediately after she had been prevented from working at Anne Sutherland House. Please remember that bit because the tribunal decided not to. Mrs. Edmonds had not raised the issue of Maria Keenahan with anyone else. Her view was there was not a shred of evidence to back up the allegations which had been made against Maria Keenahan. Richard Turner's statement, paragraph 56. I received replies from Mr. Kelly to my letters who stated that Maria Keenahan had been redeployed at Faircroft because he had insufficient evidence to continue her suspension due to the fact that the written allegations made by the whistleblowers had not been able to be released to him, and therefore he felt that the balance of evidence against Maria Keenahan was insufficient to keep her from being employed. I made it abundantly clear in correspondence that I did not agree with this view. She had been on bail at the time of her redeployment for theft, and that with the other allegations of such a serious nature that we had received, we demanded that her suspension continue. Richard Turner, paragraph 60. Care First Partnerships Limited received the first draft of the completed inquiry report on August 3rd, 1999, and the final version after correspondence between us by the 5th of November 1999. We considered that we had made our position abundantly clear with regard to all those members of staff who were implicated. It was made clear at the time when attempts were made for Maria Keenahan to be employed at Anne Sutherland House that this was not appropriate, and Mr. Kelly finally agreed that this was the case. I have a full record of the communications that took place between myself over the weekend of the 28th of August and Mr. Kelly with Mr. Kelly over the possible redeployment of Maria Keenahan at Anne Sutherland House. This was Richard Turner's statement to the Ashford Employment Tribunal in the case of the BUPA 7. The Ashford Employment Tribunal verdict, page 33, paragraph 96, quote, it was decided to place Miss Keenahan in Anne Sutherland House, another home run by the respondent, at the end of August. Mr. Turner learnt of that intention and told Mr. Kelly that the proposal was unacceptable to him. Mr. Kelly agreed not to place Maria Keenahan at Anne Sutherland House. Paragraph 102, the Ashford Employment Tribunal verdict. Towards the end of November, Mr. Kelly decided that it was now appropriate to employ Maria Keenahan at Faircroft, another home run by the respondent. Mrs. Hawke and Mrs. Chubb became aware of this fact and brought it to Mr. Turner's attention. Mr. Turner wrote to Mr. Kelly and complained about Maria Keenahan's re-employment. Summary by me. The verdict finds also that this fact is not connected to the resignations of the whistleblowers, the resignations that stated. We feel, as we have had to report the carer, Maria Keenahan, to the Civic Centre 3 times, with regard to 3 of your care homes, this has made us realise how hard it would be for us to continue to work for you, as if we had to report abuse in the future, we know no action will be taken to stop abuse. We feel we can no longer work in care as a result of the abuse we witnessed. We feel that at all times we did our best for the residents in our care, and we know if we had to fight abuse again, we would not hesitate to do so, and as a result of this, we feel we have no place in your employment, unquote. However, this evidence clearly contradicts this conclusion in the verdict. In order to judge Mr. Kelly's credibility, consider the following. Mr. Kelly attempted to place Maria Keenahan in the first care home, Anne Sutherland House, on the August 31st, 1999, and was stopped by the regulator. Mr. Kelly then placed Maria Keenahan in Faircroft on August the 31st, 1999, the same day he was prevented from placing her in the first care home. The verdict cannot reconcile this fact and find Mr. Kelly credible. The evidence available is completely ignored, and instead a conclusion is reached by the tribunal that is totally contradicted by the facts. This is not the only issue. Over 300 other issues are contradicted in the verdict. Conclusions by copious independent factual evidence. Had the verdict been a magazine citing such content, the whistleblowers could have sued for libel. However, because a judge tampered with evidence, he is immune and unaccountable. The fight for the truth left no stone unturned, but there was no accountability then, and there is no accountability for others who have suffered the same fate. And that is just what the verdict from the Ashford Employment Tribunal. I took it apart line by line, and in the end it was only the judge's name that actually stood up to scrutiny on the paper, and I have all of the evidence to prove this. I always have had that evidence, and we went everywhere with that evidence, and no one would listen. Well, now we will publish that evidence and let the truth prevail.